Okay. Yeah. So when you draft a contract, so what should we do? What we should like attend to? Of course, the first one is the form. Yeah. So we know in some cases the contract will be in the written form, sometimes in oral form, and sometimes the contract is done by conduct. So it's subject to the formality of the contract for us to decide the form, right? And the form, even the contract must be entered into in a written form. You need to consider what kind of form it is. So in common law system, it is a written form and it is a deed, right? But in Vietnam, it is quite similar. We have the written form, we have the notarized written form or certified written form, but in some cases, it needs the presence of witnesses. Great. So, of course, we need to think about the form, right? And meaning, of course, you can say in like the legal, well, that's why we study legal English. The legal language is different from the general language, right? In some cases, we use a term. In legal English, it has a totally different meaning from general English. So the second point here, they want to focus on the statutory language, right? We must use the language in the law to reflect the meaning of that situation. Now, for example, when you say statute of limitation, or the statutory limitation to refer to the time frame that we need to comply with before we bring an action to the courts. And then, for example, in case of contract, if you want to bring an action to the court, it must be within 2 years from the date. From the date there is a wrong action, or the plaintiff must have been aware of that illegal action, right? So they have the statutory limitation, then we must use the term statutory limitation or the statute of limitation. We cannot use any other words to refer to that, right? Or when you want to enter into a contract and then one party needs to give an offer to the other party and the other party give an acceptance, right? Is there any other word that you can use besides offer? Yeah, sometimes people use proposal. That proposal and acceptance, offer and acceptance. That's all. We cannot use any other words, right? Because it is a statutory language. We cannot do something different. Like a force majeure, right? We must use that word to refer to something out of the control, something unforeseeable, and people doesn't know anything about that will happen in the future, like the COVID-19 pandemic, right? Fire and some kinds of flood. Yeah, why I say some kind of flood? Because for the flood in the Mekong Delta, for example, we'll have the flood within that time in a year. People know that is a flood. So it is not a kind of an event of force majeure, but for other kinds of flood, like in Ho Chi Minh City, if there is such kinds of flood like the one in Đồng Tháp or in An Giang, so it is considered as an event of force majeure, right? So something out of our control and we cannot foresee in advance, it is considered as an event of force majeure. And then you can say, you must use that term in a contract. Otherwise, people will not understand what it is, right? Even though now there is a trend of using bland language, bland legal language, however, it doesn't mean that we use the general term, a general language all the time to refer to something in legal context, right? So what we should discuss is about the form and the meaning of a contract. When you want to travel, you should think about those first. And then the most important thing, and also the focus of our lesson today, is about the substance. The substance of a contract means the content of the contract, right? Now, for example, you need to know, now, as a nature, contract is like people's parties are free to draft a contract, to enter into a contract. But it doesn't mean that you can do whatever you want, right? The contract must be done within the time frame, the statutory frame. We cannot do whatever we want. It is prohibited in some aspects, right? So that's why we need to think about what are prohibited under the law. Now, for example, in case of fraudulence, people cannot treat the other party to enter into a contract, especially in case of contract with consumers, right? And people cannot enter into the contract for sale of human beings. No, right? And if you want to buy weapons, to buy guns, rifles, can we do that? No, right? Of course, there are some specific parties that are allowed to do the transaction on weapons, but not all, right? For our civil persons, we cannot do that. Just the soldiers or the sale and purchase of the weapons also only be done by the government, right? The army, right? They're allowed to do so. So just some parties are, right? The next one is the we need to think about the requirements, right? That means it must have in the contract what must be in the contract. For example, we have the penalty clause, and people usually refer to the differences between penalty clause and compensatory clause or compensation clause. Now, even though you don't put the clause on compensation in the contract, and if one party is in breach of the contract and causes the losses to the non-breaching party, and the non-breaching party can sue the other party. Why? Because you can see the last section, implied terms, because it is implied by law. Even the party do not agree with each other on that, the non-breaching party can ask for damages because this is under the law. The law has already allowed people to do that. This is in tort, and you understand what tort is, right? So tort is something beyond a contract, so people don't need to agree on. In the contract, it can apply, right? So about the penalty clause, I want to go back to the differences between the compensation clause and the penalty clause. So differently from the compensation clause, the penalty clause must be agreed by the parties to the contract. Otherwise, it cannot be applied, right? So if the parties do not put the penalty clause in the contract, and later on, you want to punish the other party for breach of an obligation in the contract? You can't. Yeah. So you need to identify what are the requirements of the contract. So that's why if you want to draft a contract, you need to know the law. Not only the law on the contract in general, which is the civil code in Vietnam, but also the specific laws, specific code, even the specific code, right? Now, for example, if you want to draft a labor contract, you need to look at this, the labor code, right? And in some situations, you need to distinguish the differences between the civil transaction and the labor relationship, right? The employment relationship. So if in that case it is governed under the labor code, and in what case it is governed by the civil code, right? Civil code is something very general, and then we have the specific laws on the different aspects of law relating to the civil code, right? In conclusion, if you want to know the requirement of the law, you need to read every relevant law to the transaction in order to identify what is required, right? And in practice, if the lawyers is experienced in doing something, so interrupting a contract, they need to look at many laws at the same time, right? Because there's some law on the contract is still in their mind, right? For example, with the civil code, when you want to draft a contract, there's no way for you to ignore civil code, right? You need to read that. You need to study the civil code very carefully about the civil transaction, and then contract is just a specific transaction of the chapter on the civil transaction in the civil code, right? And where after studying about the musts, and then you need to look at the permissions and authorization as well. Like in some cases, you're allowed to do something. For example, here I have the example of the sublease or sublet. Right. You lease a house, right? And you want to sublease that house to the third party. Is it allowable? Yeah, but not all cases, right? For Vietnamese party, Vietnamese organizations, if you want to sublease and you just agree with the lessor, and if the lessor agree with you, and then it's okay, you can sublease. However, if you are a foreign entity, even though the lessor allows you to sublease, the law does not allow you to do that, right? So you should think about, you should check about the permission and the authorization, right? Who are authorized to do what? Now, choice of law. The choice of law is an important content of a contract in case of international transaction. So in case the contract is entered into between two parties from two different nationalities, and then people will consider what kind of law they will use in order to be fair to both parties. And usually they choose the third party's law. Just like when a Vietnamese party enters into a transaction with an American party, and what kinds of law should they choose? If they choose the Vietnamese law, and then an American party may feel it's unfair because they don't know anything about Vietnamese law. And then if we use an American law, and then the Vietnamese party will say, oh, I don't know anything about American law. So what should they do? They would choose the law of a third party. They choose the law of the third party. Usually they choose the law of Singapore. They choose the law of Singapore. And even for the body which deals with the dispute between the parties, and they can choose the law, or the body that deals with the dispute from a third party as well. So in case of international transaction, they will use the law of Singapore, and then they also use SEAC to deal with their disputes. That means the Singaporean International Arbitration Center instead of VIAC, right? Like Vietnam International Arbitration Center. So they choose the third party's body dispute settlement in order to, according to them, it could be fair to the two parties. Right. The next one is implied terms. Implied terms, as I said before, which is the terms like it is implied by law, or usually it is implied by law, right? Or there are some terms that a kind of boilerplate, right? This is a standard one, and that you need to like even in the standard ones, it is one of the boilerplate clauses, and it can be implied by law if you don't put that in the contract. Now, for example, the clause on amendments of the contract. So the law requires that if a contract is entered into a specific form, then its amendments are also in the same form. So this is the law, under the law. So even though you don't put the boilerplate kind of boilerplate into the contract, it is implied by law, right? Any questions so far? Now, here is the section that helps you to determine the substance of the contract. This is the checklist about who. Yeah. So just like an article, piece of paper, when you write something, you should think who, what, when, how, right? And sometimes why, right? Just pose WH questions in order to make sure that you cover everything, to make your piece of paper comprehensive. It's just the same as when you draft a contract, and you should ask the WH questions. And the first question is who? Yeah. Is either party a minor? So a minor here is a person under the age of 18. Yeah, so people under the age of 18 can only do some transaction which is necessary for their life only. It can go to the market to buy book, to buy notebook, pens, pencils. This is okay. It is necessary for their education. So they can buy clothes, yes, but not very expensive one. just for their normal days, right? So it's okay too. So the minor cannot, like in the common law system, there is a case that the minor bought a very expensive jacket, and then that transaction later on found void because according to the judge, that person did not need that kind of jacket, right? It's very expensive. Then the seller could be aware of that. So that's why when you do a transaction, you need to check whether a minor is, whether the other party is a minor or not, right? So for example, in Vietnam, the people under the age of 18 cannot enter into a contract for transfer of real property. Yeah. So even though they have a house, but they may inherit the house from their grandfather or grandmother, but you can say that the transaction must be under the supervision of their guardian, the father or the mother, not themselves, right? The father and the mother will act on their behalf because they're not allowed to do some kinds of real property or real estate transaction. So we need to check first whether the party is a minor or not. Questions? And the next question is, do both parties have the mental capacity to contract? Yeah. So if one of the party has some mental problem, can they enter into the contract? Of course not, right? So some people just have partial mental capacity problems, like in some situation that they don't have any problem, but when it's hard, so they have the problems. Then at the time of entry into the contract, it seems that there's no problem with them. But then later on, they said that because they have a problem, a mental problem, so they want the contract to be found void. Yeah, it's very risky. So that's why when you enter into a contract with another party, you should check very carefully about the mental capacity of that person, mental capacity to contract of that person. Now, the next one is any of the party a business entity? Why you need to have a question? Because for the business entity, and then we need to include what kind of information, the information about the enterprise registration certificate. We need to know that. We need the other party to provide you with the enterprise registration certificate, and then in which you will know the number, the ERC number, the address, the legal representative, who is the legal representative of the company. Okay? You need to know, and then that legal representative plays the position of what? The chairman or the general director of the company. So you must know the law on enterprises in order to know the duties of a chairman, the duty of the general director, right? And whether this contract should be entered into by the chairman or by the general director, right? The CEO. And that leads to the next question. Is the signatory authorized to sign the contract? Yeah, so if the contract is entered into by the general director, but according to the charter of the company, with the contract of that value, very high value, that should be entered into by the chairman, not by the general director. Yeah, so in a huge transaction, and you need to check also the charter of the company to see who should be the signatory of that contract. Otherwise, the contract may be found void. Yeah, so it's very risky. In practice, the thing is that the contract is entered into by a branch or by a head of a business office. Is it okay? The answer is no, right? Because the branch or the business office is not a business entity. So the head of the branch or the head of the business location cannot sign the contract unless they are authorized by the authorized signatory of the business entity. Does it make sense to you? Questions? Do you understand?
Yes, I have no question.
Yeah, thank you. Yeah. So we go on with the substantive term, the checklist for the content of the contract. So the first question is about who, and the next question is about the what, right? So what is the subject matter of the contract? This is a contract for licensing, for transfer the use of software or of an application. Yeah, you should know the subject matter of the contract to determine whether that is allowed by the law or not. And the amount and the method of payments. In almost every contract, you need to have the consideration, right? How much the other party will pay, the buyer will pay, right? And the method of payment. And forex. Forex means foreign exchange rate. In case the country is entering into between two different nationalities, then they may use the USD. Then they need to agree on the exchange rate to convert the USD amount into the Vietnamese amount. Because every transaction in Vietnam needs to be done in Vietnamese đồng, not in any other foreign currency. Right. So method of payment is very important. Usually, lawyer needs to work with the finance in order to determine the method of payment. The methods of payment are very varied. Can be like pay in cash, pay by bank transfer. So those are seem simple. But in case you pay by the letter of credit, pay by the guarantee agreement, by a promissory note, right? It could be complicated then. Right. And what else? For lawyers, you don't care much about the financial status of the company. If you are the buyer, and then you can agree on the payment, whatever the other party wants, in order to ensure that the transaction goes smoothly, and you want to speed up the execution of the contract, and then you can agree on whatever method of payment that the other party suggests. However, from the financial standpoint, there would be big problem in choosing the payment method. Now, for example, if you choose 40-60, that means you deposit 40%, and then after the delivery, and you pay another 60%. Is it okay? It's a hard question, right? So it's subject to the financial status of the company, and it's also subject to the other party. I mean, the third party, not the party to that contract. Because you buy, for example, you buy food in order to resell. But when you resell, how long you can get the money back? For 30 days. And then you need to agree with the person who sells the material to you. The payment term is around 30 days to 45 days, or even 60 days, just to ensure that the third party sends you money and you send to the supplier of the materials. And it's a problem, it's a math that the financial team needs to consider. And then the legal team just like ask them to confirm whether the payment term here is okay or not. Yeah. About the forex, the exchange rate. So have you ever seen the exchange rate of a bank? Now, let me show you. Now, people usually use the exchange rate of Vietcombank. You just open the website of Vietcombank on the exchange rate. And here, this is the foreign currency and purchase and sell. And purchase will have in cash or transfer and sell. So when people agree on, for example, we have a transaction in Australian dollars, then what kind of rate should you agree on? You choose the selling rate or the buying rate. Or with the buying rate, so we choose in cash or we choose in transfer. You can say it's a big difference between the selling and the buying rates, right? So that's the question that the party need to solve out when they enter into the contract. So what kind of rate should they apply? Buying, selling, or the average of buying price and the selling price? And when you say about the buying price, and you should think about what kind of buying price. Yeah. US dollars. Well, US dollars get down. However, with the Australian and Canadian dollars, it goes up. In the first time of pandemic, and the Australian dollar is just like around 14,000, around that, but now it's 16, right? And for the Canadian dollars, this is, it's somehow unchanged. But for Australian dollar, it goes down. Yeah, sometimes it go up to 25,000. Usually 23, but now it's lower than 23,000. Right, so if people have money now, they will buy US dollars at this time, and then they can sell and get some, some difference in the future. And you can look at the Singapore dollars, right? Wow, it is even higher than the Australian dollars. And you can see how Singapore develops. Okay, so this is a forex. It means the foreign exchange rate that you need to know when you negotiate, when you draft a contract, and you ask your client to take care of that and to put that into consideration. Yeah. And for what, we also think about the processing and delivery, because it relevant to the transfer of title. Like when the products change the title from the seller to the buyer, who will process that, and on what date they will deliver the product to the other party. Yeah. And for the substance of a contract, about what, we also put into consideration about the presentations and covenants. Right? I think you have learned something about presentations and covenants, right? In your legal English, you know, presentation is just the statements that something is true, and covenant refer to a commitment in the future, right? And default events, like I I told you about the EOD, an event of default. So here it is. What you should tailor, what you should track is an event of default in the contract. Of course, in the law, they have event of default, but the parties can agree something more on the event of default, right? And also the remedies. In case of this breach, what is the remedy? In case of that breach, what is the remedy? So the remedy can be applied for each kind of breach, or it can be applied for the whole contract. So it's up to you as a drafter to decide to just for the benefit of your clients, right? For example, for the remedies of like a force majeure, so if the persons who suffer from the event of force majeure, they need to inform the other party right after that event, and they have 30 days to cure the situation. And after that day, if they fail to cure, the parties can agree on the termination of the contract, right? They have the time for remedy and for cure, right? So this is a question about what? Any questions? So of course, in what we have a lot of things to do. Now, the next question is about when. But before we go to when, I would like to have a 5 minutes break. Okay, so we go on. The next question is when, right? So we go through who, what, and now when. You know, in a contract, time is very important. It may like cause some legal consequences. Now, I think you know the term time is of the essence already. Yeah, in case the time is very important, and if one of the party is in breach of the time, and then that breach is considered as material, and the other party can terminate the contract. Now, I can take an example. When a party wants to buy a contract for sale of commodities for Christmas, and you know, every year there's only like one day for Christmas, and if they want to sell something for Christmas for decoration, they need to sell that around 1 month before the Christmas, or at least 1 week before the Christmas, right? And if the person who sells the products to you for resale deliver that product after the 24th of December, you cannot sell it to anyone else. That's no use. That's nonsense, right? So in the contract, we will like write in the contract that time is of the essence. The time here is for the delivery, and the time is very important. It is of the essence, right? So if the seller is in breach of the time, the buyer will terminate the contract. Yeah, and sometimes people use the term reasonable time. The question here is, should we use the term reasonable time or not? What time is considered as reasonable? Yeah, the reasonable time gives the party some flexibility, but sometimes it causes ambiguity and also cause disputes, right? So the question here is, should the term reasonable time be used? I cannot answer that question. It depends on the situation. Sometimes the answer is yes, and sometimes the answer is no, right? And previously, we discussed about the method of payment. And the method of payment usually go with the time of payment. So when they will pay. Yes. And the time to answer the question when, it also refers to the duration or the term of the contract. So the contract is entered into on that day, and when it ends, what is the expiry date of the contract? Yeah, it's a question. And when you like track the term of the contract, there are many questions rising from that. Like for example, is the contract automatically renewed after the expiry date of the contract? And so after the expiry date of the contract, what should the party do? Do they need to enter into an agreement to termination of the contract, or when the contract expires, so the obligations between the party will end, there is no further action? So you should think about that, right? The next question is where? Where the contract is performed, is it in Vietnam or is it in the USA? So if the contract is performed in Vietnam, and then it will relate to the choice of law, right? And for where the employee will work, if it is in the labor contract, so the head office is in District 1, and you enter into the contract with the head office, with the company in the head office, but then they have a lot of branches around the city, then they may ask the employee to work in District 10, District 11, right? And in the contract, we should clearly define where the employee should work or will work, right? And the where also refer to the jurisdiction. So the jurisdiction here refers to which country will deal with the dispute. So if there is a dispute, so which country will deal with that, right? So even in case you choose SEAC, you choose Singaporean law as the law which governs the contract, yes. Then you choose the SEAC, Singaporean International Arbitration Center, to deal with the issue, yes. But where? So SEAC can deal with the issue in Vietnam. SEAC can solve the problem and can gather the arbitral tribunal in the US or in Singapore. So it depends on the agreement between the party. So when the party agree on the dispute settlement clause, especially in case they choose arbitration, so they should choose like which arbitration center, what kind of rules, what kinds of rules that people use, the language, the number of arbitrator, and the location of a jurisdiction. Yeah. Any questions? And how? For example, in case of construction contract, the building needs to be built by a general contractor, or that contractor subcontract to other subcontractors. They have the E&M contractors, or the general contractor can deal with everything. So how can they implement the contract, right? Now, the thing that you usually see in international transaction is about the pass of risk, right? If the party choose CIF or FOB, freight on board, right? Like cost and insurance and freight. So this is the Incoterms in an international transactions that have the Incoterms, right? So when should they use those terms? The party need to agree on how they pass the risk based on what terms. Now, I would like to give you the scenario. You're working at the Department of Human Resources. and you want to hire a new office manager and need an employment contract, and you're going to meet a potential candidate in order to discuss the employment contract, please prepare a substantive checklist. Prepare who, what, when, where, how. Right. Now, please prepare a checklist. So I would like to give you 15 minutes. You can discuss with your friends in whatever method, and then prepare the lists. Okay. So can you share with me the checklists? Now, first, to answer the question, who? Ngọc Mai?
Yes, teacher.
Yes. So what are the checklists? So what are the questions or the details of the checklists about who?
I think I will ask them about the personal information like the name, and is that candidate old enough to work or just a minor, and does he or she have the mental capacity to the contract, and
so, you're gonna ask that kinds of questions to them, so how can you ask? Do you have any mental problem?
Oh my God, how can I think I will require them to provide me a certificate to prove that they have no anything related to the mental problem.
So what if you, that graduates, and what if when you submit for a position and then your employer asks you to show a certificate, that kind of certificate, what do you feel?
Okay. Because I have no idea how to check whether they have mental problem or not.
It is when you have the interview, and as a human resources manager, you are trained to know how people are, right? Just some questions, some very normal questions, and you can guess if they have any mental problems or not. Yeah, so you don't need to ask them to show you the certificate, because they need to have the medical checkup booklets. That means they need to show you the result of their medical checkup in order to make sure whether they have enough health to do the work or not. They are subject to what kind of work under the law. For some professional jobs, like working in the lab, in the laboratory, working in a dangerous situation, do mining jobs. So they need to have a special kind of health certificate, right? But for some others, just do a normal checkup. And this usually sent together with their CV, and you can look at that, and you can know their status, right? Okay, what else?
I think I will ask them did they used to work before, and if they say yes, which position, and with which position that they used to work.
So the questions are about their experiences, right?
Yeah.
Okay, so sorry class, you're gonna have the second shift, so we should stop here and just do it carefully as your homework, and see you next time, and we'll discuss again about the checklist. I'm sorry for that. Yeah.